another hearing proceeding and Potanin.
Thank you, well, Lord, my ladies. I'm going to start with the set-aside test, which is, we would submit, the real point on this appeal, given that issue 2, 3 and 4, we say, is put on a false premise. We submit that the test should be whether the judge was materially misled, as set out in paragraphs 94 to 99 of our written case. As to what material means in this context, we submit that it is whether, but for the misleading, which may be by commission or omission, leave would not have been granted. And Milady asked yesterday whether there was a successful case of the knockout blow. Well, there is in the bundle M and W, which is at page 1263, and that was a successful set-aside application in which Mr. Justice Coleridge found that there was a knockout blow. And the knockout blow was that the original judge who gave leave, Mr. Justice Baker, as he then was misled about the status of an agreement between the parties in New Zealand, and he was told that it had not had approval from the court and therefore was not binding on the parties. By the time of the set-aside, expert evidence was adduced that that was incorrect and the judge had been misled, and it was decided that was a knockout blow. Now, the test that we put before the court is the essence of the test.
Was it found that that had been a deliberate misleading of the court?
Can I get Mr. Nagpal to check? I'm not sure that that was actually addressed, that it was deliberate, but
it doesn't really matter anyway. I mean, it's going to be very rare on that test, and if there's one or two, then...
well, I was invited to identify one, and that was a material misleading. It was obviously of critical importance, because with an agreement that was binding, that's obviously a different category to here. And of course, what the wife in that case said is that since that agreement, she'd fallen on very bad times. And the court said that that was, Mr. Justice Coleridge said that was tough because the agreement was on. But we are not on that basis. We say the injustice was at the time of the Russian orders. The test we put forward is the essence of the test for setting aside permission to appeal, as set out in the judgment of Lord Justice Sedley in the Hertsmere Borough Council case, at paragraph 2, and the reference for that, I'm going to not turn it up, is 1528. And it was cited and then applied by Mr. Justice Moylan, as he was in AA and BB, at paragraphs 81 and 87. Respectively 1123 and 1124 of his judgment. And Hertsmere is in fact still cited in the White Book at Rule 52.18, subparagraph 2, as being the test. Why should that be the test, I now turn to? Well, we recognise that this is a high hurdle, but we submit there are good reasons for that high hurdle. Before elaborating on that, I'd like to take you to the authorities which lead up to paragraph 33 of Agbargi, which show that set-aside had presented long-standing problems and that set-aside applications had been getting out of hand. And we say that Agbargi sensibly addressed the concerns, and what has happened in this case, because of what Mr. Justice Cohen decided about a 3-day hearing, show the wisdom of Lord Collins's observations. Could I turn to 1253 first of all?
Sorry,
1253, the case of Jordan.
That's the last page of Jordan.
The last page.
Yeah.
As Simon Brown, LJ, as he then was, has pointed out, in the field of judicial review, once leave is granted on an ex parte application, an attempt to discharge inter partes is much discouraged. It must be questioned whether the present practice in the family division does not lead to waste of cost. Rule 3.17 provides for the ex parte application where leave is sought under Part 3. A subsequent application to set aside is not specifically provided for under the rules, but in my experience such applications have been commonplace. There may be good arguments for moving it once to the inter partes hearing, which would test at once whether or not leave in principle is contested and assist the court to determine its substance. So that was the suggestion to deal with the problem of Lord Justice Thorpe at that stage, the year 2000. And then, if we could go back to page 1154, which is Mr. Justice Mumby at first instance here. And my learned friend read out paragraph 65, but I draw your attention to paragraph 66. Present case illustrates...
Sorry, where are we now?
Sorry, 1154.
115.
I'm sorry, I'm going too fast. Beg your pardon.
No.
.1154. Paragraph 65 was read by my learned friend. Paragraph 66. Present case illustrates the baleful effects of the rule and of the continuing failure to amend it. The wife's application for leave was made as long ago as the 28th of September 2005. It's now the 18th of December 2006. Well, of course, that pales into insignificance with the delay here. The process, and this is simply an application for leave, has taken the best part of 15 months and no doubt involved substantial costs. May I respectfully suggest that something should be done to amend Rule 3.17 with a view to implementing Lord Justice Thorpe's wise proposals. And
what were his wise proposals that the rule ought to implement?
Well, his wise proposals is you should move
straight to an inter partes hearing and not have an ex parte hearing first
Exactly.
of all.
Exactly. That was...
Well, that seems to make a lot of sense, and that's what it's now said the judge should have done here.
But that wasn't done. That's what if I could follow it through, it wasn't done.
Can I just check that I've understood what he means by the inter partes hearing? What Lord Justice Thorpe meant by the inter partes hearing in Jordan and Jordan, because he could have meant an inter partes hearing of the application for leave without having a full hearing ex parte, or he could have meant the main hearing of the application for relief. And I'm not sure which he means, and I'm not sure which, therefore, is it Mr. Justice Mumby at this stage was blessing.
No. Well, I think that's a fair point, my lord.
Well, yeah, but you ought to know. You're a family division practitioner.
No,
You ought to know what the slang means.
Well, quite frankly, I don't know what it...
Okay.
I don't know.
But I mean,
I've always interpreted it to mean because of a subsequent application to set aside is not specifically provided for under the rules, but that's what he's talking about is the inter partes hearing. That's what I've always assumed.
What, you mean the main hearing?
No, the set-aside hearing.
I think that must be right, because he said what he's complaining about is the fact that you have to have an ex parte hearing when you know you're going to have an inter partes one.
Yes.
And
That's
so
what
you
I
should
think.
go straight to the inter partes hearing for leave.
But the strange thing is that the family division practice that then ensued of doing, of notifying the other side that you were making an application for leave,
Yes.
and inviting them to come along, so it was in reality an inter partes hearing, would appear to respond to this invitation.
Yes. But then...
And yet then it gets stamped on as being a practice which, quotes, must stop, quotes.
Exactly. But it must stop.
It's neither one thing nor the other, is it? It's neither an ex parte hearing, nor is it actually giving the respondent a sufficient time to prepare for a proper hearing as to whether leave should be granted. Presumably, the notice that is given for an ex parte on notice hearing is much shorter than the notice that would be given for a proper inter partes hearing of the leave application.
Well, as I frankly said, that I'd never conducted an ex parte on notice in this area, but I mean, you could give notice the night before, certainly.
Yeah.
I mean, I mean,
And
you're out with the rules.
Yeah, and that, if
And
that's
then you
treated as the
can do what you like, and then it'd be up to the judge what he does.
But the purpose was to inform everybody about whether leave itself, as opposed to the final relief being sought, was contentious.
Yes. Yes. Because
And if it was going to be contentious, then the advice from Lord Justice Thorpe appears to be, well, don't bother about an ex parte, it goes straight to an inter partes.
but that wasn't the route followed. That's my point, because it then moves on. But I wanted to.
But just to make absolutely certain I understand, you accept that that was the practice that Lord Justice Thorpe was suggesting at the time?
He was suggesting.
Don't worry about the ex parte, go straight to the.
Yes, that was his suggestion.
Yeah.
For dealing with the baleful effects of the rule. Yes.
So the family judges didn't speak with one voice.
No, but things moved on. That's what I was coming to. But I wanted to.
Mr. Howard, before you move on, there's a world of difference between these two different meanings of the inter partes hearing. It goes to the whole essence of your case, I think. For my part, I have difficulty at the moment in understanding the reason for the antipathy of family division judges to an inter partes hearing in these circumstances. If you could help me on that, I'd be very grateful.
Well, because they got out of hand, and Lord Collins came to the solution he did in paragraph 33, which is what I'm coming to.
What got out of hand?
Set-aside application.
No, but you don't have a set-aside application if you have an inter partes application. I think we established that yesterday. If you
yes, but I mean, inter partes applications could get out of hand as well, by the same way, because they can become mini trials.
And is there any evidence, are you going to show us now, of complaints in the family division about that?
Well, this is a complaint about it. This is a.
No, it's not. This is saying you should go straight to the inter partes hearing and
yes.
not have an ex parte hearing first. So, are there then complaints about having an inter partes hearing at all? So you shouldn't even bother with one. You should just have an ex parte hearing.
Well, that was the solution.
Only hear from one side, and you can save a lot of time that way.
That was the solution that was adopted, and the position is that, as was said to the Court of Appeal, inter partes applications are very, very rare. Apart from this brief period when there was a practice, obviously, because it's referred to in traversa impredi, and that's what happened in that case, of giving informal notice. The practice has been for there to be ex parte applications, followed, if necessary, by a set-aside. But I wanted to.
Although now we're told the President of the Family Division has issued a direction in complex cases, you shouldn't do that. You should go straight to an inter partes.
Well, not quite. He's saying that it's a matter for the allocation judge.
All right.
But of course, you could make submissions about that, but it hasn't amended the rule. But what I wanted to emphasize that the complaint that is being made here is not about the ex parte applications on notice, as the court has seen later in traversy, but rather set-aside applications following an ex parte application. And as you rightly pointed out, the main solution that was contemplated is the change of the rules so that we get rid of the ex parte procedure, which was mandated at that time, altogether, and the judge have an on-notice application. That is our understanding. Although one may infer that Lord Justice Simon Brown was positing an alternative solution that operated in the administrative court at that time. But I now wanted to turn to Agbaji in the Court of Appeal, because quite a lot was said about this by Lord Justice Ward. And what I wanted, the point I'm making is that when we come to paragraph 33, there was a lot of raw material that was taken into account by Lord Collins. And if one looks at, first of all, pardon. 1155. Thank you. 1163 I wanted to start with. Thank you very much. Paragraph 10. On the 8th of February, the wife brought her application. The husband's response to it was, in my opinion, misguided and unfortunate for reasons I shall explain later. He sought to set aside the leave that had been given, and voluminous evidence was filed on each side to deal with that application. Exactly what happened here. And of course, in relation to the query, there was an inter partes application. In this case, it would have been exactly the same. Then go to paragraph 30, if you will, which is on page 1170, where Lord Justice Ward says, rules were to prescribe and do prescribe how this application should be made, and a deliberate feature of the rules, as envisaged by the Law Commission, was that the application be made ex parte. And then going down to just above G, although the hurdle is set somewhat higher, the judicial task remains essentially a quick impressionistic assessment of the merits, bearing in mind the object of the exercise. And then there's reference to Lord Templeman's remarks, which came up yesterday. And then paragraph 31, what I have found to be unsatisfactory is the apparent readiness of respondents to challenge the grant of leave instead of getting on with the substantive hearing. Of course, the ex parte order can be upset if there's a serious failure to give full and frank disclosure. But the practice of arguing the merits at this stage is almost invariably a complete waste of time and money. And that would also apply to an inter partes hearing.
But he then says that Lord Justice Thorpe made the same point in Jordan and Jordan, but that's not the point he made in Jordan and Jordan, as I see it.
Well, he did say it was a waste of time and money, I think.
Well, yes, but he was saying that the answer wasn't to go straight to the main hearing.
I know.
But to have an inter partes application for leave.
Yes.
And indeed he then quotes the passage saying that.
And then he quotes the passage.
He interprets it, as far as I can see, differently.
Yes.
They're talking about two completely different things.
Yeah.
Yes.
It's like
then,
ships passing in the night.
what I want to highlight is obviously the discussion that clearly was before Lord Collins, who then came to the solution he did. And then in paragraph 32, I would commend the family division to follow the practice of either the administrative court or this court.
Well, what is the current practice of the administrative court in relation to setting aside a ex parte order granting leave to apply for judicial review? Is that by way of a rehearing?
That is, yes.
Yeah. So both sides are reheard?
Yes, right. On that, yes.
Yeah. Was that the practice?
Was
that the practice in 2010?
No.
It wasn't. Right. So if we're enjoined to follow the practice commended by the administrative court, that is now different.
That is now different, yes, that's right.
And so the set-aside test wouldn't apply?
No. No.
Yeah. Okay.
So now it's particular to the family division. Paragraph 33, as for the difference between the application for leave and the substantive application, this was admirably expressed in the Law Commission's report, and that paragraph I read to you yesterday. Yes. It's the uncontroverted statements. Paragraph 34. There seems to be another potential danger in so fully arguing the merits in an attempt to set aside the grant of permission, which again would also apply to an inter partes application. It may have been demonstrated in this case, bearing in mind that a necessary finding when considering the giving of leave is whether or not there are substantial grounds for concluding that it would be appropriate to order relief. Then there's a risk the child judge will pay undue deference to the judgment, which its status as no more than the grant of leave does not deserve. Here Mr. Justice Mumby gave an admirably short and concise judgment after an apparently short but perfectly adequate hearing.
For him, anyway.
Well, I think it was quite, yes. Held without notice to the husband. Well, that is exactly, we say, what Mr. Justice...
For whom was it adequate, then? Not probably the husband.
Well, it was an adequate hearing to address the test in Section 13 on the basis of uncontroverted statements.
There's a difference between not getting fully into arguing the merits, which is obviously to be avoided, and not giving any opportunity to present any case at all.
Well, but you do have an opportunity on the set-aside to say that the wife, in this case, misled the court.
Well, that's no opportunity to present your case, because as you just said, it's only once ever happened, thankfully, that in the family division the judge has been sufficiently misled.
Well,
unless that is done, you just don't get an opportunity to present your arguments at all.
My Lord, I didn't say that. I said there is an instance in the papers of a set-aside.
All right, well, it's not going to be very common. In the vast majority of cases, you simply denied an opportunity to make submissions to the court.
I don't necessarily,
on the merits of the order being made.
I don't necessarily accept that. I mean, this respondent was given a full opportunity to answer the points. He put in a very long statement. It was a 49-page skeleton argument, thousands of pages of exhibits. But
the Court of Appeal said that must all be ignored because the judge wasn't misled. So he shouldn't have been given any opportunity at all.
My Lord, no. The 49 pages of skeleton argument and the husband's statement were all addressed to the misleading.
Well, it was all addressing a totally unproductive issue instead of focusing on the question whether the test is met or not, which should be the focus, surely, of the inter-parties hearing.
The answer to that is that when this case came before Mr. Justice Cohen, there was a mandatory starting point of an ex-parte procedure. And that's what the rules said. But
the rules didn't say that on the set-aside application, you must waste your time arguing about whether the judge was misled the first time round, and unless you show that, you're not allowed to make submissions on the merits of the point.
You are allowed to make... I mean, that's where we come to paragraph 33 of Agbargi. That sets aside... That's the set-aside test. And
I know, but what we're exploring is why that should be the test and whether it's either fair or there's any justification for it.
Can I come to that in due course? Because that is part of... But I wanted to follow through how we got to paragraph 33 at the moment, and then I'm going to deal with why it's the proper test.
Just before we do, can we just look at the quote from the Law Commission report, which is quoted at paragraph 33, talks about on the basis of the applicant's uncontroverted statements.
Yes.
That's not of itself, is it, an invocation that it should be done ex parte? And we all know that a summary judgment application is, generally speaking, made on the basis of the applicant's or the claimant's uncontroverted statements of the evidence. And the summary judgment application or the strikeout application must show that on that basis, nonetheless, he's going to lose. But there's no suggestion that is done ex parte.
But the Law Commission did recommend an ex parte procedure.
Yes. And I'm just trying to see how you get from a perfectly sensible appreciation that you're not going to have contested factual issues at this stage to a perception that it has to be ex parte.
Well, I mean, the answer, I mean, it was the recommendation of the Law Commission, and it has been the practice throughout. And I mean, I'm going to come to, but I say that what Mr. Justice Cohen did was perfectly appropriate. He was addressed on it, and he decided to hear it ex parte.
Just before we leave paragraph 34 and this risk of the trial judge being intimidated by somebody else, there are two points there. First of all, I mean, is that a real risk that people forget their judicial oaths? And secondly, in any event, isn't the judgment on a summary application not meant to condescend to details? So the details are left. It's a summary procedure.
It is.
And it is not a judgment delving into the depths of a case. And so that leaves it open for the actual trial judge to decide whatever he wants to decide, even if he was intimidated.
But in this case, what happened, despite Mr. Justice Mumby, we say, giving a short judgment on leave, well, on the set-aside, he gave a much longer judgment, which, of course, is in the bundle at...
Well, that may not be desirable. Normally in judicial review, if you're giving permission, you don't give much in the way of reasons because you don't want to tread on the ultimate thing. You might give more reasons if you're denying leave, because that's the end of the story then.
Yes. Yeah. But I mean, the set-aside judgment here is 23 pages. In Agbargi, it starts at 1125, 29 pages, in fact.
Presumably because it was effectively dealt with as a rehearing inter partes.
Presumably, yes. And that is what the court.
Not a have you got a knockout blow type of.
Yeah. Well, that wasn't.
No, nobody.
There was no guidance.
But if you give leave, you don't have to give a long judgment. You can give a very short one.
And one shouldn't give a long
You
judgment.
shouldn't give a long judgment.
Yeah.
But
if you're refusing leave, it's something else. Perhaps you might have to give more detailed reasons why it doesn't meet the test.
But this is the background that we say that the Court of Appeal, that the Supreme Court and Lord Collins was addressing. And if I could now turn to paragraph 6.
Forgive me, before you move on, I understood you to say, Mr. Howard, a few moments ago, that the test applied in the administrative court for setting aside an ex parte grant of permission to apply for judicial review had changed since the date of the Court of Appeal decision in Agbaji. I'd welcome some, not now, but at some point, some assistance on that, because I'm not sure that that's right.
Oh, right, well, maybe I've got it. Perhaps I can leave Mr. Nagpal to deal with that at the end of my submission.
Very well.
Is that all right? Rather than ask him and then...
Yes.
I think that might be more convenient, and I'll leave him to think about it. Is that all right? Huh?
Yes, of course, but it's a point that we must return to, because the analogy is clearly important.
Yes.
And it's important to know whether, in fact, there has been a departure from the practice which applied at the time of the Court of Appeal in Agbaji.
Just one thing before we leave paragraph 34, this idea of the trial judge paying undue deference. Is it not the practice that the trial judge will be the same judge who granted leave, or a different?
Not necessarily.
Not necessarily.
Not necessarily.
But if there's an ex parte hearing and it then comes back inter partes on a set aside, is that usually the same judge that will decide?
Not unless the judge reserves it to himself, or there's been an allocation. But what happened in this case, that at the ex parte hearing, Mr. Justice Cohen did reserve it to himself, but that doesn't necessarily follow. Huh? I mean, AA and BB is a good example of that. Came before Mrs. Justice King, as she then was, and Mr. Justice Moylan dealt with the set-aside. Then I wanted to turn to what Lord Justice Longmore said, because he also pitched in on this. Paragraph 66, 1182. I must, however, like Lord Justice Ward, express my disenchantment with the procedure adopted in this case. The wife applied for leave to apply for relief on the 28th of September without notice to the husband. Mr. Justice Mumby granted that application in a fairly short judgment on the 24th of November. The husband then applied, as he was apparently entitled to do, to discharge the leave so granted. And then paragraph 68, one can only say this is extremely luxurious litigation, and alarmingly so if, as in the wife's case, it's all done at public expense. It's also strikingly different from the procedure adopted on judicial review applications to the administrative court or applications for permission to appeal to this court. In both these spheres, applications to discharge, permission to move for judicial review or permission to appeal, granted as they will have been on the without notice applications, are strongly discouraged and are usually only granted if it can be shown the court has acted in ignorance of some statute or binding judicial decision. Then the case cited.
But has there been a change in relation to applications for permission to appeal, insofar as are litigants now, proposed respondents now entitled to make submissions?
They're entitled, yes, but the practice, as was identified in Traversi and Freddie for a very long time, has been for them to make.
So
I mean,
the contrast, sorry, and was that the practice at the time of Agbaji, that those opposing applications for permission to appeal had a right to make submissions?
I don't think so at that time, but I will.
Yes. But because, again, I'd like to know whether the analogy is correct.
Yes, I understand that. That, in my view, should also be the practice of the family division in operating the requirement for leave to apply to the court to make an application under the 84 Act. I would suggest the Clerk of the Rules should not list any application to discharge permission given without notice to make an application of the kind here in issue for any more than 20 minutes, and that any application for a longer time listing should be supported by a written explanation from counsel and put before a judge of that division before any longer listing is given. The concerns of Lord Justice Thorpe seem to have been ignored, and it's time that some action was taken. So that is the background, we say, and of course Lord Collins would have had that, to the observations he made and his conclusions in paragraph 33. And he deals with that at 1191, paragraph 23. It's necessary to set the course of the application for leave out in some detail for two reasons. And then 2 lines down, the second reason is that the enormous delay caused by the husband's application to set aside gives rise to considerable disquiet about the procedure in Part 3 proceedings. And then paragraph 24, while I'm here, can I refer to it on another point? You can see that Lord Collins approved in paragraph 24 by necessary implication to what Mr. Justice Mumby had said in his ex parte judgment. Mr. Justice Mumby referred to the very considerable discrepancy between the aggregate value of what the English court would consider to be the relevant matrimonial assets and the actual provision to the wife, and concluded that the very significant discrepancy in the very modest amount of the provision made for this wife following a marriage of that length in relation to a case where there appear to be significant assets is such that, having regard as I do to each of the facts and matters set out in section 16.2, there are established substantial grounds. So this is a case where there is a considerable discrepancy between the aggregate value of what the English court would consider to be the relevant matrimonial assets, which are the beneficially owned assets. So I don't have to come back to that. Paragraph 29, if I might. The consequence was that the leave process took that time and that the subsequent hearing did not come on until April 2008. This is a shocking delay to which has to be added the time taken in appeals to the Court of Appeal and this court. Paragraph 30, as indicated above, the filter mechanism for leave was recommended by the Law Commission. Working party paper suggested that the ground for leave be that in all the circumstances the case was a proper one to be heard, but added, paragraph 53, note 195, that the court would have an inherent power to deal with individual cases in the most convenient way, e.g. by adjourning an application for leave to enable evidence to be filed by the other side, and by dealing with the applications for leave inter partes. So clearly Lord Collins did envisage circumstances where there could be an inter partes hearing. And then paragraph 31, Rule 3.17 provides for the ex parte application where leave is sought.
I think that's a reference to a rolled-up hearing, isn't it?
What?
What you just read, to be accurate. He's talking about adjourning it to be heard at the same time as the real hearing, the substantive hearing.
Well,
isn't he?
No, because he says, and by dealing with the applications for leave inter partes.
And if leave is given with the substantive matters at the same hearing.
Yes.
Yes.
So, I mean, there are two alternatives.
That means that it's sometimes one adjourns, one deals with a permission to appeal, and the substantive appeal of permission is given all at one hearing.
Yeah.
But he's envisaging two alternatives there.
Oh, yeah.
One is you adjourn it and deal with it at the substantive hearing. The one is you deal with it inter partes.
Well, we needn't worry too much, but I think he's only positing one myself.
Well, he does say, and by dealing with applications for leave inter partes.
And if leave is given with the substantive matters at the same hearing, it's all one sentence.
Paragraph 31, Rule 3.17 of the rules provides for the ex parte application where leave is sought, but a subsequent application to set aside is not specifically provided for under the rules, although it is, of course, a fundamental rule of procedure. The court may set aside the making of an ex parte order on the application of the respondent. Concern has been expressed at the delay caused by the applications to set aside. See Jordan, see Mr. Justice Mumby, and see Lord Justices Ward and Longmore. So he clearly had in mind all those passages. It is clear that something must be done to prevent the waste of costs and court time and prejudice to the applicant caused by the applications to set aside which have only questionable chances of success. That must, of course, be balanced by a proper application of the threshold of substantial ground. But as Mr. Justice Dean said in the Federal Court of Australia, in an entirely different context, the word substantial is not only susceptible of ambiguity, it's a word calculated to conceal a lack of precision. And that is the run-up to paragraph 33. And then Lord Collins says, what is the solution to it? And that is the guidance which has ruled the procedure. Since then, there was obviously, almost at the same time as the decision in Agbaji, because you remember in Traversa and Freddie, the decision came out in the middle of the deliberations in the Court of Appeal, where there was a practice of going ex parte on notice. Traversa and Freddie brought that to an end. And that's the context that you get to the second half of paragraph 33 and its reaffirmation in Traversa, and your lordships and my lady have seen that paragraph and what Traversa and Freddie said. So what is in...
Do we have a copy of CPR Rule 52.9 brackets 2, which he refers to?
That specifically says, doesn't it, that you can only set aside if a compelling reason is shown.
Yes.
Unlike the rule in the family rules and CPR Order 23. On the face of it, it's a different test.
So the Family Proceedings Rule Committee could have gone along a different route. They could have said, well, we're going to scrap the ex parte procedure and have an inter partes procedure instead. But that is not what they've done. And we set out in paragraphs 51 to 53 of our written case how the rules have evolved. And the rule was quite clearly, as a result of what Lord Collins said, and Traversa and Freddie, that we have a default mandatory ex parte leave hearing. And that was a deliberate decision which the Rule Committee put beyond doubt by the 2017 amendments. Now, can I then deal, as I said I would come to this, why the material misleading test, we say, should remain as it is? We do submit that set-aside applications, and indeed long inter partes applications, should be discouraged. Part 3 applications apply to all manner of litigants and cases, and it's not hard to conceive of a respondent having a go, even only as a delaying tactic or a weapon for wearing down the financially weaker party. And we set some of our points about that, and I'm not going to, I just refer them to you to our case, which is at paragraphs 175 to paragraphs 102 to 118. Pages 175 to 179 in the bundle. We secondly say that the current test has had the desired effect. It's very difficult to set aside leave, we accept that, just as it is with permission to appeal. But our submission is that's how it should be. If this court introduced a lower test for set aside, or that, contrary to the rules, that there should be an inter partes procedure invariably, we are likely to return to what Lord Collins and, of course, the judges in the Court of Appeal and Mr. Justice Mumby clearly thought were the bad old days.
But there's a missing piece of information before we work out whether this is all worked out fine, which is how many times is leave given, and then the husband has to provide all the financial information and the parties prepare for a hearing with all that financial information, and actually no order is made because the judge decides England is not an appropriate venue for making this order. I mean, if that happens, that's then not a good outcome. Would you accept that?
Well, I heard what Mr. Nagbal said sotto voce. Neither of us know any case where that has happened, where there has been leave and then the court has said no. Except for Zamina, which was an agreement case. And
So you're saying that the court at the substantive hearing does not, in effect, review the Section 16 criteria? No,
it does review it, right, because you certainly have to get over that hurdle. But your lady's question was, I mean, there are no statistics about this, but anecdotally, neither Mr. Nagpal and I know of a case or have been in a case in which leave having been granted, we come to the final hearing and the judge says, well, actually, I've now considered the Section 16 criteria and I don't think you get past the Section 16 test, i.e., it's, in my judgment, it's inappropriate for the English court to make an order. Certainly, there are many decisions in the bundle, all where leave was given, and there were substantive orders. But, I mean, it is absolutely open to, and that is absolutely clear, and we don't gainsay it, that a respondent who is the subject of a leave application can run the Section 16 arguments. He can say, number one, it's not appropriate for the English court to make an order, and number two, if you apply Section 8, in any event, if you apply Section 18, an order should not be made on the merits. So, I mean, there are two issues for a judge hearing a substantive application. One is the Section 16 test, and then you go on to consider what, if any, order is made on the merits. I mean, obviously, and what Zamina said is that those two procedures should be heard at one hearing, that one shouldn't have a preliminary issue on Section 16. And certainly my experience is that apart from Zamina itself, where the judge at first instance was criticised for doing that, the invariable practice is that if you have leave, then both issues are considered at the same hearing. So I was making my submission that if a lower test is introduced, we're likely to return to what I've perhaps described as the bad old days. It also undermines the need for a mandatory default ex parte procedure in the first place, which was envisaged in the Law Commission report and in all the rules and all the cases. And what we say about that, if there's going to be a de novo hearing, then it's a waste of time having an ex parte hearing at all, because the leave application is never going to be urgent. I can't envisage circumstances in which it would be urgent. So this is why it's completely different to the analogy of an ex parte freezing injunction. It's different in this way. The norm in going for a freezing injunction is to go into parties. But if you can establish urgency and something is going to be happening which renders the relief you're seeking nugatory, that is, someone is about to take all the money from England to Dubai or Saudi Arabia, where there'll be difficulty of enforcement, then you would go ex parte. But
well, I have to say, Mr. Howard, I can't ever remember being involved in a freezing injunction application made inter partes. You go ex parte because otherwise the chap will do exactly what you're trying to stop him doing because you tip him off.
But that's because of urgency.
Well, not urgency, no, privacy. You need to get the order in place before he knows you're asking for one. But it's another good...
Because he might do something. Because he might do something.
Well, because you then serve it on the blank.
That is the urgency. So if you write him a nice letter and say, please don't take this money out of the jurisdiction, or, and then he does it, it's too late.
But is it a helpful analogy, Mr. Howard? Because the effect of the grant of an injunction ex parte is that the position of the parties is materially affected, the legal position of the parties is materially affected until such time as the injunction is discharged. It's very different from the grant of permission to bring...
Oh, exactly. That was the next point I was going to make.
But isn't this a bit similar to service out of the jurisdiction, where there's an ex parte threshold first? And I take the rationale to be that there are some cases where it's obvious that permission shouldn't be given, and somebody who's perhaps a foreigner with no connections whatever with England shouldn't be put to the trouble and expense of having to come and attend an application to argue about jurisdiction or hear whether leave should be given if it's obvious that it shouldn't. And so
but that's
a reason for having an ex parte application first.
But that is dealing with whether the English court has jurisdiction. There's no doubt here that the English court has jurisdiction.
No, but there's some analogies in there because it's the question of whether you exercise jurisdiction also applies, in fact, on the service out. One of the things you have to show is that England is the appropriate forum and that you've got a reasonable prospect of success on the merits. And those are similar sorts of questions to the ones here.
But two of the ingredients don't apply here because there isn't a forum non-convenience test, which there is on service out. And secondly, you don't have to show a jurisdictional gateway because that is already dealt with by Section 15.
I appreciate, but I'm not saying it's exactly the same, but I'm just asking you whether there might not be a similar rationale that somebody who has no connection whatever with the jurisdiction shouldn't be put to the trouble of having to instruct lawyers and contest proceedings here, even if only at the initial stage, if it's obvious to the judge ex parte that it's a hopeless or a vexatious application.
Yes, but here what is being decided ex parte, which is what the rules mandate, is whether there is a substantial ground for making the application. And that's and of course, Part 3, as Mr. Nagbal's passed me note, could apply where both parties are here.
Well, in that case, the judge would probably dispense with the ex parte hearing and go straight to inter partes. There's always the discretion, isn't there, under the rule to do that appropriately?
There is, but there is a mandatory ex parte starting point. And as I say...
Well, it's the default position if the judge doesn't alter otherwise.
It's the default position, but there are the words must in it.
But your main point at this stage is simply that if the set-aside is to be dealt with as if it were a rehearing, then judges or allocation judges will want to know whether the application for leave is contentious, and if it is, will generally want to adjourn the application for leave to an inter partes hearing to avoid the duplication involved in hearing it ex parte once and then completely rehearing it again inter partes.
Well, that's certainly possible, yes.
And I thought that was your point, really. I mean, you're saying, and that would completely undermine the ex parte by default rule.
Yes.
Yeah.
I mean, I repeat that, I mean, often urgency or something is going to happen, or there is a fear that something might be happening, or you're giving notice to the other side where they might do something, doesn't apply to this mandatory ex parte, because there can never be urgency. A respondent, can't take a step which is irrevocable. All we're dealing with here is something which doesn't direct him, like a freezing injunction, to do anything. All it is deciding is that there is, on uncontroverted statements, a substantial ground for bringing the application. Not that it will succeed, but there's a substantial ground for the bringing of an application. And that is, we say, perfectly appropriately going to be dealt with ex parte on uncontrovertible statements. And if there's going to be on set-aside, and I am dealing with the set-aside because that is what is in issue here, and that's going to be a de novo hearing, then it was a waste of time ever having an ex parte hearing, which is futile. And I repeat that the analogy with ex parte injunctions misplaced, no order against the respondent, and excuse me, and section 45, which my learned friends relied upon, we say is to the same point. It's at page 2257. Of the bundle. Again, we say this is not a suitable analogy.
Sorry, 2257. My bundle stops at 2256.
It was added to the bundle.
Not to our electronic bundles, I think.
No, it'll be an addition. Yeah.
It'll be an additional. Let's see if we've got it. When were the additional documents lodged?
At the end of last week.
Oh, so it's a...
It was sent, I think...
Family Law Act 1996.
Is that it?
Yes, Family Law 1996.
Yeah, it was added.
Okay.
Thank you. It's a separate...
So this is a statutory order about ex parte orders. Now, this is not an analogy because an ex parte non-molestation order, and particularly an occupation order, could require something positive, i.e. leave your home. It's a very dramatic ex parte order to make. A non-molestation injunction imperils someone's liberty, and the rationale for going ex parte is obviously urgency. Normally a wife or a partner needs protection, and needs protection without any delay. And the norm, of course, under the Family Law Act is to go inter partes. And what Section 45 provides, that obviously there is a specific specific provision that it must afford the respondent an opportunity to make representations relating to the order as soon as it's just and convenient. And that's a specific statutory provision, obviously, for a de novo application. But that is perfectly appropriate here because of the dramatic nature of the relief, and also because the norm would be to go inter partes. Now, aligned to the point that I'm...
So the rationale in the 1984 Act for ex parte applications is what?
The rationale is that it's to be decided on the uncontroverted statements of the party, and it's meant to be a short listing, and it's meant to be to look at the Section 16 considerations to see whether, of course, there is an obstacle or not to the granting of leave, or whether leave should be granted. It's an essentially summary procedure. And on an ex parte order for an occupation order, of course, it must be open to the husband to be able to say, or the man or whoever, well, look, actually, what she says is completely wrong. I never did that. And that must be fed into the mix. Now, aligned to the point I'm making is that...
That's a rationale for a summary procedure. What's the rationale for not hearing the other side?
Well, not hearing the other side is that the way in which you can set aside an ex parte order is to say that the court has been misled.
Would you accept you can set aside an inter partes order on that basis too? Saying that the court was misled is actually a reason for reopening an inter partes order.
Yes.
Made, isn't it?
Well,
so really, you have no greater protection under your analysis than you would if there were an inter partes hearing.
Except, of course, in an inter partes hearing, one would have expected the respondent to that to have pointed to the misleading.
Yes.
And to have been adjudicated. I mean, it's hard to imagine if there's an inter partes hearing with a husband or a respondent having a full opportunity to have his say. And what would have happened in this case, there would have been no difference to what the respondent would have said. Effectively, what he said in his 34-page statement is the court was misled. And that's what he would have said on an inter partes hearing. So I say rhetorically, what is the difference?
Why would he have had to say that on an inter partes hearing?
Because...
Well, there wouldn't have been an ex parte hearing.
Because he would have said, actually, the presentation of my former wife is misleading.
Well, he might say that, but whether it was
He did say that in this case. I mean, one does have to
He
concentrate.
said it in this case because he was bound by a procedure which only enabled him to get his foot through the door on the set-aside application if he could show that the court had been misled. But if it had been a simple rehearing, he could simply have come along at very modest expense and say, well, you don't get within a mile of passing the connection test, and therefore you shouldn't have granted leave.
Well, obviously, that's a very simple point to make, and it was a point that we acknowledged on the ex parte application.
Yes, but it's one thing to acknowledge it, and another thing to hear counsel in full bore asserting it.
Well, you say that, my lord, but I mean, it is a very simple point. I mean, my client never said, for instance, that they hadn't lived in Russia throughout the marriage. She never said that. And when it came to on connection, because that's what you have asked about, when it came to connection, the husband here did not contradict what my client said about her time in England after the marriage. What he said is the very simple point, which we say Mr. Justice Cohen took into account at the ex parte hearing, is that she said, I intended to live here permanently in 2014. I spent an increasing amount of time from 2016, 2017 onwards. I spent the majority of my time here. When you take into account I was on holiday elsewhere. It was my permanent home. That's what she said. Now, when it came to him putting in his statement, he could have said that was misleading, but he didn't. He didn't make any comment at all.
There could have been a factual dispute about whether it was misleading, which would not be determined on a summary application. But the significance of the factor could have been argued.
Could have been. He could have said...
He could have made submissions about...
Well, it's just wrong.
Taking that at his height, uncontroverted, and looking at all the other factors, well, there are no substantial grounds. In a short, summary way.
Yes, but those factors, because I did want to come to the judgment, were taken into account on the judgment.
Yeah.
Well, they were, but you're saying they shouldn't have been. And the Court of Appeal said that, because the judge wasn't misled, so he wasn't allowed to look at that.
I meant the leave judgment, my lord. I mean, it
mean
was
the
clear
ex-parte
from the leave
the
judgment that
original
the court knew. The court, if you look at my client's witness statement, she never said that the parties lived during the marriage anywhere but Russia. I mean, that was common ground.
But your case seems to be premised on the basis that it doesn't make any difference to the judge whether the husband is there or not making submissions. But
well, provided he's not misled.
How the justice system is.
Provided he's not misled. I mean, we come back to
Well, you could apply that to any hearing. This is the problem. And Lord Collins said that it's a fundamental rule of procedure that the court may set aside the making of an ex parte order on the applications. Why is it a fundamental rule of procedure? Answer, because it's fundamental that before you make an order, you give both sides an opportunity to say something on the merits of the point.
Yes, but he had the opportunity and did avail itself on the set-aside. And that was the route that Lord Collins went along. He had, in this case,
he didn't.
a 3-day...
You shouldn't have had.
Sorry?
You're saying you should not be allowed on the set-aside to make submissions on the merits of the question whether leave should be granted unless he can show that the court was misled at the parties' hearing, which he couldn't. Therefore, in the great majority of cases, the respondent should not be heard or given an opportunity to be heard before the court makes an order. And that does, on the face of it, seem inconsistent with the fundamental rule of fairness.
The position is that if you're going to proceed, as was recommended, on the basis of uncontroverted statements, then if the statement is not misleading, not demonstrably misleading, we don't say that there's an unfairness. That's my answer to that. And allied to the point is that this is not a merits decision. It is not something that is adverse in any way to the respondent putting whatever case he wants. He's entitled to take all points at trial. And we say the current system strikes a fair balance. It gives the respondent an ability to apply to set aside on a knockout point and a right to have everything investigated at the substantive hearing. And that fits in, we say, with the notion that the assessment of the leave is only meant to be rough and ready and not a rigorous evaluation. And the cost points that the husband makes are really inappropriate here, because this is a case that has got out of hand in cost terms, and as we pointed out, what has already been spent, we could have had a hearing, probably 2 hearings for the price. And we say also that what we propose is in line with the leave test. I've made that point. It's in line with the overriding objective, which is at page 934 of the bundle. All those considerations of the overriding objective are completely in favour of what Lord Collins decided. And we've got the example of this case. The delays experienced, we say the pressure from a very rich respondent with the costs being racked up. And looking forward, we say that the effect of the President's guidance may well mean that more leave applications in the future are held on notice in any event. But that doesn't retrospectively change the procedure in this case. And my Lord Legate talked about the introduction of an opportunity to put in 3-page objection submissions, but whether that should happen or not is something we say for the Rule Committee to consider and recommend, because it would require a rule change. Because at the moment, the application must be made ex parte unless the court otherwise ordered. The position generally I've addressed, but returning to this case, our submission remains the test is correctly applied by the Court of Appeal, and thus the appeal should be dismissed. But of course, if the court concludes that the test was wrong, well, then we're in grounds 12 and 13, and they are live grounds.
I was looking last night at your ground 13. As far as I could see, all you said in your skeleton argument was one paragraph saying the judge was wrong in his decision, which doesn't seem to address the fact that he was exercising a discretion. And unless there's some basis for saying that he exercised it on a wrong basis or that it was outside the range of reasonable decisions, and I couldn't see any such submission made to the Court of Appeal.
Well, the Court of Appeal concentrated on the misleading point, and no doubt about that.
No, I was just looking at your grounds of appeal and your skeleton argument. It didn't seem to be any more than saying in one sentence the judge came to the wrong result. Is that a fair statement or an unfair characterisation?
Well, the position is that we say that if that is going to be argued, because, of course, we say that he was wrong because he failed to take into account, for instance, AA and BB. He didn't deal with it. He didn't deal at all with my client's connection with Russia being severed. And he made findings of fact about the misleading, which infected the second part of the process. And of course, having told my client, having told me at the ex parte hearing he didn't want to have any information about her movements pre-2016, he then made a comment about it. But I was going to come. It's my next category to look at that judgment, and then I can explain why we say it's wrong. And of course, but the Court of Appeal were addressed extensively about ground 13. That is still live, despite Section 16.3 being repealed, because this application was made.
That's your main regulation.
That's the main
regulations. Yeah.
Yes. Can I then?
So just what are you asking us to do then? Because you made an application for the matter to be remitted to the Court of Appeal if we were to allow the appeal. Is that still your position?
Well, yes, it's our primary position. If the appeal, obviously our primary position is the appeal should be disallowed, then we don't get there.
I assume
if the appeal is allowed, then, there are alternatives. In a sense, what has happened here is, or it could be said that the whole procedure went adrift from the start, and that is the set-aside application was on the wrong basis. The Court of Appeal proceeded on the wrong basis because everyone assumed paragraph 33 of Agbarji was the test. And so really the set-aside application, I mean, the only thing that really would stand in that analysis is the ex parte order, because no one has applied other than to set it aside. The set-aside is on a basis which the Court of Appeal have found to be inappropriate, and there's no criticism of that process in the grounds of appeal in this court, and so the ex parte order stands. And therefore we say that if we're going to look at whether leave was appropriate, then there has got to be a substantial rehearing. I mean, one alternative is the Court of Appeal, another alternative is a first instance judge. But our prime position is that it should go back to the Court of Appeal. But of course, that Court of Appeal, there's some difficulty about it being reconstituted at the moment because Justice Richards is now in this.
I think also because of sanctions and so forth, some years have gone by now, and they effectively be starting again, wouldn't they?
Well, I know that's the problem about the delay. And of course, the other point that will arise on all this, because the main plank against my client is connection, but of course, since Mr. Justice Cohen was dealing with it, 5 years have elapsed, and my client's connection, there's a lot of new evidence which throws light on my client's connection, and...
You're not really suggesting we start all over again, are we?
Well, what I am saying is that it's totally unrealistic now to see connection in terms of 2019. I mean, that really is, any court would be flying in the face of reality. And if one's going to think...
That's not how it operates on appeals, though, is it? We have to look at the position as it was when the judge made their decision.
Well, but I mean, if we go to reconsider ground 12, then, I mean, there will be argument as to what you look at, because there is something completely unreal about addressing lack of connection to this country when by then my client will have been here, will have decided to come here for 9-10 years and will have been here for about that time.
Yes, but other factors in section 16(2)(a)(I) may also have shifted over that period.
I'm not sure that's necessarily right.
But presumably the Section 16 tests are to be applied. I mean, Section 16 starts by referring to the court shall not make an order unless, or words to that, if I can't remember precisely.
Yes.
So presumably that test has to be applied at the time when the court's about to make its final order, i.e. at trial.
Correct.
So the fact it may have been appropriate on day one of the proceedings to do it, if it's become inappropriate by the time of the trial, then you don't make an order. Of course, if vice versa, you probably wouldn't get leave. You'd have to bring a new claim if you say circumstances have changed.
Section 16 refers...
Section 16 is clearly canvassed about, it's all about whether you make an order.
Yes.
Yes.
And that looks forward, as your lordship says.
Yeah.
And Section 16 talks about connection in the present.
Yeah.
It's not past connection.
Well, past connection comes in under other circumstances.
Yes, but you have to look at present connection.
Yeah.
So if there's going to be a reconsideration of the merits of the leave application, is exactly what I hope submitting perhaps ineptly, you have to project forward to the final hearing. Because the test is there grounds for substantial grounds for an application for an order being made? And that takes you forward to the eventual trial. Of course, when Mr. Justice Cohen was considering it, the eventual trial might well have been in 2020. But now we are 4 years on, 5 years on from the application. And if you're going to start deciding, well, that my client doesn't get leave, or Mr. Justice Cohen's decision was correct, one has to, because, and he found, of course, my client was a divorce tourist. And it's really rather artificial to see that in terms of 2023, end of 2024.
It may be artificial, but unless he decided it on a wrong principle or erroneously exercised his discretion, then if you lose on the primary point, then that decision stands.
But can still make a further application if you want.
I can make.
Yes, you could start again, but it's not something to open up in the part of the appeal process.
Well, I mean, we haven't got to ground 12 yet, and I want to keep my powder dry, but I think that that's not a submission that I will that necessarily agree with, if I might put it like that, or an argument. The position is that because one has to take into account the delay, and as I was pointing out, you do project forwards, and projecting forwards in 2019 is rather artificial when you know what has happened.
But if depending on the outcome of this, either Mr. Justice Francis's order for directions and to the service of the Form E and the capital schedule will be triggered, or it won't. But that presumably has to be assets as at the moment the schedule or the Form E is completed.
Yes.
I mean, that's what's going to be the difference here.
And if there's a trial, it will be on the basis of my client's connection at the time of the trial.
And what assets there may be here or elsewhere.
Yes. And as you will see, you will have seen from the order, that was part of the order that Mr. Justice Francis made, where the assets were, because we don't necessarily know.
No, we don't.
That's why he made the order he did. But you have now seen the order, and clearly this was being case managed to keep the investigation process to a minimum, and we went along with that. I mean, not a full Form E, only a capital schedule, no expert evidence, and a cap on what we were claiming. Can I address the consequences of this court changing the set-aside test? I mean, we submit there are three possibilities. Maintaining the current test is obviously one. That's what we advocate. Consequence of that is that the appeal is dismissed because there's no appeal against the Court of Appeal's conclusion that Mr. Justice Cohen was not materially misled. Secondly, this court decides that a set-aside application simply involves a de novo reconsideration. The consequence of that is that our grounds 12 and 13 come to the fore, which is not before this court, because we say Mr. Justice Cohen was wrong in his reconsideration. And if that was the conclusion of this court, we say it undermines the whole mandatory ex parte starting point, which has regulated applications now for nearly 40 years. And the set-aside was considered on completely the wrong basis. And as I've already indicated, takes us back to the ex parte order. The next is that the Supreme Court, this court decides the set-aside test is somewhere between the two. The consequence of this depends on how this court defines the new test. So if, for instance, the test becomes that a respondent needs to prove there was misleading and that misleading might, but not necessarily would have made a difference as to whether leave would have been granted, then in this case the appeal should still be dismissed because Mr. Justice Cohen was not misled, whatever the threshold for materiality. But if some completely different sort of test, like a summary judgment test, i.e. a respondent had to show no real prospects of success, which is not the obverse of the substantial ground test, then we submit the respondent couldn't satisfy that test either, bearing in mind all the lacuna cases and especially AA and BB. But at the very least, it would require a redetermination of his set-aside application because it was determined on the wrong basis, and it would also bring ground 12 to the fore. And I wanted then to address any unfairness here in this case. We say, and I wanted quickly to go to the judgment, that Mr. Justice Cohen took into account everything. He made the right decision, he applied the right test, and he was right to hear it ex parte. Nothing more could be said about the fundamentals at any hypothetical inter partes application. When the set-aside hearing took place, the husband essentially said misleading, which was all he could have said at an inter-partes hearing. And what he did was to persuade Mr. Justice Cohen to make inappropriate findings of fact, and that's why we say the paragraph 33 test should persist, paragraph 33 of Ag Bargi. When Mr. Justice Cohen moved to the leave re-grant, which absolutely mirrored what the husband would like to be reconsidered the inter partes, we say the whole judgment is infected by, one, his views on misleading, secondly, that he gave no opportunity to my client to answer what the husband had said.
Could you just say, what do you mean by it was infected by his views on...
Well, by the time he got to that, he decided my client had misled him. But he made findings when he gave no opportunity to my client to answer the witness statement. He only gave her an opportunity to answer financial misrepresentations. And he made inappropriate findings of fact. There are criticisms in the Court of Appeal judgment of not sitting inter partes. Well, that, we say, is an aside, and we reject that criticism. And in fact, in the Court of Appeal, I was not asked to argue against that finding, because of course it wasn't part of a cross appeal. And in fact, and I only give you the reference, page 859, Mr. Leach, leading counsel, did not criticize the application and the argument that the court should sit ex parte. What he said is that with the benefit of hindsight, it would have been better to have been inter partes. And what Mr. Justice Cohen did was make a discretionary order about being ex parte, and he has exercised a case management decision, and that would not have been subject to any successful appeal, and indeed, as my Lord Briggs said, no appeal was made. And can I then look the court at the two decisions to substantiate what I say? The ex parte judgment is at page 237. Paragraph 2, he deals with his decision to sit ex parte. Paragraph 2, he deals with my client being fully entitled and that all the matrimonial assets were made during the marriage. There's no dissension about that. He then goes to the Russian proceedings and my client's assertion that she only got 40 million out of a total of 19 billion. And he highlights the lacuna point in paragraph 4, which again is common ground. He then applies section 16, and you will see he makes the point in the third line of paragraph 5. The parties had no connection prior to 2013, but a schedule's been produced me today, and which is to be formally exhibited, shows that London has been her principal home since at least January 2006. I've not asked for any diarisation going back before that date. She's lived over the last 3 years far more in London than anywhere else, the main other place she has visited being America, where the party's youngest child is living and studying. Her visits to Russia have been very limited due to various adverse circumstances which are set out in her statement, unnecessary to refer. She has plainly established a connection with England and Wales. 6, she did have a very strong connection with Russia, but that connection has now been very largely severed and remains in existence only because her elderly mother, and she was 99 at the time, who cannot travel for health reasons outside that country, is living in Moscow. Apart from Russia, the wife has limited connection with any other country outside England and Wales, and certainly there's no other country at the present time with which she has a greater connection. He then turns to, over the page, paragraph 7, section 16(2)d, already received an award by virtue of the award of the Russian court, but she says it's subject to the very significant deficiencies which I've already referred, which is the injustice point, which it's common ground that the court didn't consider that. Her rights to claim in Russia are now exhausted, and after 4 years of litigation, there's no further appeal process. She says there's proceedings taken against her. Again, I don't think that's in dispute. And then paragraph 8, he deals with delay. Paragraph 9, he deals with enforcement. And then he comes to his decision. Tests for grant of leave are met. And I have, of course, applied the test of whether there are solid grounds or substantial grounds for the court to be able to say that an order might be made. I'm satisfied for all the reasons I've given that those grounds exist. If, of course, the husband feels he does have what is sometimes known as a knockout blow to the application, open to him to make an appropriate application. And we say perfectly appropriate judgment based on uncontroverted statements, but a lot of what's there, the husband has not controverted subsequently. Then page 241, we have the judgment, and I wanted to highlight what our criticisms of it and our comments on it. Paragraph 19, page 245, clearly saying that the crux, the last sentence, the crux of the application is being misled. Paragraph 28, last sentence, he makes a finding about Russian law, which we say was not appropriate. Last sentence. Then in paragraph 33, he makes the comment.
These are presumably points that were made by counsel for the husband.
Yes, yes. Paragraph 33, I mean, an unfair point. Why, W has not suggested this quote which H has produced is erroneous, but she didn't have an opportunity to answer that witness statement. Completely unfair. Paragraph 33, it seems clear to me that in every instance the Russian courts have consistently and properly applied Russian law, a finding about Russian law. And you can see in paragraph 37, he didn't want to consider what we had to say about that. Paragraph 40, again, another finding about Russian law, page 250. Paragraph 44, much of the hearing before me has been taken up with H's case and an equal time. So that was what the hearing was all about. It was based upon paragraph 33 of Agbaji. Then if we go to paragraph 49, you can see the only reason is that he's again addressing misleading. And then paragraph 51.3, we've dealt with that in our note, the impression. Paragraph 52.2 is about Russian law. And then paragraph 59 was clearly about being misled. He then goes to the reconsideration, which is the ground 13 point. And you can see at the end of paragraph 63, he says, before 2015-16, this is page 256, there's no evidence that she spent any significant time in England. Well, he hadn't asked her to go back earlier than that. It's completely unfair, we would say. Paragraph 67.
Well, had she spent any time?
Yes, from 2014 onwards. But she had no opportunity to address that. Okay. And then paragraph 68, he makes this comment about the New York, the Long Island property. But he didn't say that the rationale for that was that Vasily was at school around the corner. Just didn't mention that. And then paragraph 70, what this does show in my judgment is W's connection with England and Wales is both recent and modest. Well, we say a completely unfair finding because recent is comparative. Well, you could say 5 years is recent, but to say it was modest is just inappropriate. If it is your home and your only home, your connection is not modest, it's total. And he then goes over the page, 258. The parties' connection with Russia, the country where the parties were born, was infinitely greater. But he doesn't point out that he's got to consider that now under section 16.2, and he says nothing at this stage about the fact my client has severed her connection with Russia, which was clearly relevant. Paragraph 80, 259, he makes no mention of the lacuna point or the beneficial owned assets point. Paragraph 81, he talks about bites of a cherry, but of course we say she never had a bite on that particular cherry at all.
Mr. Howard, I thought the rights and wrongs of this part of the judgment weren't before the court.
Well, I just wanted, because my Lord...
I mean, you've seen, I understand procedurally why that's happened.
I wanted to show how it all got out of hand, really.
Okay.
I mean, that's really
I'm just trying to see for what purpose you're deploying at this point.
A, it got out of hand, and B, to meet my Lord's argument that we didn't have arguments on why the judge got it completely wrong.
Yeah, I see.
That's really... But I haven't got... Paragraph 88, 260 is a finding that she was a divorce tourist.
Yes.
Completely inappropriate. And paragraph 90, we say, completely misunderstands the lacuna point. And then 92 is simply because W has suffered what she regards as a very significant injustice. Well, it was objectively. Oops. Sorry, I've knocked something off. Excuse me. Whether it matters. That someone else can do it. Other way around. I wanted then to make a few remarks on the paper and the authorities about a lacuna, which obviously has been raised. 1150. And indeed, 1150, you can see significantly, sorry, this is on the last point, Mr. Justice Munby saying, well, we've had this set-aside hearing, but it didn't change the fundamentals.
So whereabouts on page 1150?
Paragraph 57, my Lord.
57, thank you.
Doesn't significantly affect the fundamentals. 1153 is clearly him repeating what he says on the lacuna point. Considerable discrepancy between the aggregate value of what this court would consider to be the relevant matrimonial assets and the very modest amount of the provision made. Absolutely appropriate here. And then
you're saying that whenever there's that kind of discrepancy, there must be a lacuna, or just one have to look at... I thought your point was more specific, that it's the inability of the Russian courts to deal with beneficially held assets that was a lacuna.
And that is them having a different view on what are relevant matrimonial assets to ourselves. This court would consider that beneficially owned assets are part of the assets.
Yes.
The Russian court does not. And that's exactly what triggered the application. I'm not suggesting that lacuna is enough in itself, but it is one of the considerations. And then paragraph...
So what paragraph on page 1153?
Paragraph 60.
60, thank you very much indeed. Thank you.
1153, sorry, that I've dealt with that. 1191, paragraph 24 is effectively Lord Collins approving what Mr. Justice Munby had said in the proceedings. And then, importantly, paragraph 76.
Which is at page?
1204, I do beg your pardon.
Thank you very much indeed.
Which was the basis of
Sorry, could you give the reference again, please?
1204, paragraph 76.
Thank you.
Last bit. Very last 4 lines. Very large disparity between what the husband received and what the wife received, such as to create real hardship and a serious injustice. Absolutely we say, what has happened here. Can I then turn what my Lord I do beg your pardon. Lost a sheet of paper. But it was what my Lord Legate said yesterday about the matrimonial home when I was dealing with it. What he said, my Lord said, is that the Russian court decision actually decided how the former matrimonial home should be distributed. And we were asking the English court to say the allocation should be revisited. We say that that is not the case here, because what the Russian court did was not decide how it would be distributed. The Russian court decided that it was not part of the matrimonial assets and therefore did not deal with where it should be distributed. And that points, we say, to the comity point.
Is that Autumn House?
The Autumn House, yes.
Well, I think
So the Russian court said it's not on, to use our metaphor, it's not on our radar because it's in the name of someone completely else. My client said that that person was a nominee, the husband was the real owner, that it was intended to be their full-time matrimonial home. They had many matrimonial homes, but that was going to be the main home, and it costs 150 million. And there are documents he exhibited which show that the two of them were intricately involved in the building process. But it ended up in the name of a nominee. The Russian court did not decide as a matter of discretion, this is allocated to the husband. It said it's not within our jurisdiction. And that is really the lacuna point. And it's the comity point, because there's no improper conflict.
But you go further, really, in the sense that even if the Russian court had decided that it was to be distributed in a certain way, there still is jurisdiction in this country under the 1984 Act to deal with it. And that underlies the whole basis of the Act.
Yes. But it's... I was really dealing with it to deal with my Lord Legate's comity points.
Yeah.
And we say there is not an improper conflict, because it's not as though we are saying to the English court, look, the Russian court got it wrong when they decided as a matter of discretion that this asset would go to the husband. They didn't decide that. What they decided was they had no jurisdiction. It's a lacuna. And it's a very major asset. I mean, the figures in this case are enormous, but it's a house that my client said, and there was no contradicting, costs $150 million. And on the comity points, I am running out of time, but I want to say this. The statute envisages a second order. No doubt about that. It's section 13.2, section 16.2f, and section 18.6. Agbarji confirmed that, and the paragraphs are paragraphs 50, 52, 50, 52, 58, 54, and we deal with it in paragraphs 156 to 161 of our case on comity, and we say there is no improper conflict. The Russian court did not decide he could keep the beneficially owned assets as a matter of discretion. And what is particularly, we say, unjust here is the husband used non-Russian concepts, that is trusts or nominee arrangements, to protect him in Russia. And it doesn't really lie in his mouth to say when part 3 comes, well, the Russian court dealt with it fully. And nowhere in the statute does it say or imply that if there is a decision in Russia that there's connection after a divorce, then there's no possibility of a claim whatsoever, whatever the injustice, and no sharing of needs. And we say that is not what the statute says. And the statute clearly allows a case based on lacuna, And obviously, you don't consider that in a vacuum. You consider that in the light of all the Section 16 considerations and all the circumstances of the case, including, of course, connection, which is current connection. So there's jurisdiction here, so there is that connection. The sole question is the filter. That looks to connection without a prerequisite of either that being a condition, that it has to be substantial, or indeed it is a term. Section 16.2, as I say, is in the present test, and I've already said the artificiality about that. I now wanted to turn to the case that the court sent us, Ahmed and Mustafa, because really that does bite upon comity, and I wanted to make the following observations about it. It was a very different factual matrix. I mean, if you revert, you obviously have to reverse the situation, because the question was an anti-suit injunction to stop proceedings in the Turkish Republic of Cyprus. But the differences are, unlike in this, the wife was not the petitioner in Russia, whereas the wife in that case was the prime mover in England. No undertaking was given by her in Russia. There was therefore no breach of an undertaking, although that wasn't central to the decision. It went to her conduct, and that's paragraph 25 of the judgment. The order prohibited further applications. That's again not the case here. And of course there was no anti-suit either application or order in Russia. On the principle that the judge decided that the follow-on jurisdiction under Part 3 was internationally acceptable. So it was perfectly acceptable to have ancillary financial provision in two jurisdictions. What justified the anti-suit injunction is that it was, whether it was unconscionable due to conduct, and was it unconscionable to make further applications? And I'm not going, that's dealt with in paragraphs 21, 22, and 23. And the words used were vexatious, oppressive, manifestly unfair, a denial of justice, where those actions can't be justified. Well, my client does not come with any of these. It can be justified because of the lacuna, let alone any influence. It's not the very same issues in the two jurisdictions. In Ahmed, the English court could deal with Turkish property, or Cypriot Turkish property, and could deal with needs. The English court had full jurisdiction wherever the assets were and could deal with needs. And what the wife was trying to do in Ahmed was start all over again, completely replicate what the English court had done. Here we are inviting a supplementary jurisdiction, and we are not seeking to relitigate matters that were decided conclusively in Russia. The Russian court did not decide whether or not these assets were beneficially owned. It said it was irrelevant. In this jurisdiction, it's common ground that they were beneficially owned. The Russian court did not decide what my client should have for her needs. They weren't considered. And because of that, I hope it was circulated that we referred to a judgment in a Singapore case. It did come.
Thank you.
Thank you. Which is quite interesting on the question of comity. I mean, what happened in that case was that there were full Singapore proceedings. The Singapore court decided it couldn't deal with a London property. Thank you. Sorry. Couldn't deal with a London property. The wife said it could, but she lost on that. So very considerable parallels. Then a Part 3 application was made, and the husband went for an anti-suit injunction. That was and I would refer to paragraphs 5 and 6. First importance to note that the answer to the issue just set out must surely be one of substance and not merely form. Literal or descriptive similarities and or differences ought not to be legally or normatively determinative of themselves. Here, hence, for example, notwithstanding the fact that an application for financial relief in the English court might appear to have a different purpose from the previous matrimonial proceedings in the Singapore court, if the former is in substance a relitigation of the latter, then that would, in our view, be impermissible, as it would undermine or subvert the public policy relating to the finality as well as integrity of the Singapore courts' decisions in relation to matrimonial proceedings. In that event, an anti-suit injunction might indeed be granted by the Singapore court in order to restrain proceedings that are initiated in England. What would constitute relitigation would depend on the precise facts and circumstances of the case. However, in the present case, we are of the view that there's been no relitigation insomuch as the claim initiated by the appellant for financial relief pursuant to Part 3 did not engage the distribution of the property in relation to matrimonial proceedings simply because the property was not considered part of the pool of matrimonial assets in the first place. An exact parallel to here. What then of the argument that the Singapore courts, by holding the property was not part of the pool, had in fact rendered a decision with respect to the matrimonial proceedings, and that therefore the claim initiated by the plaintiff for financial relief pursuant to Part 3 did constitute a relitigation of this particular decision? And that, of course, is what is said here. No lacuna, because my client argued this point in Russia and lost. Whilst a not unattractive argument, it's our view that the fact the property had not been considered part of the pool meant that not a single iota of the property could ex hypothesi have been the subject matter of distribution to one or both of the parties, pursuant to the matrimonial proceedings. Looked at in that light, the subsequent claim initiated by the appellant pursuant to Part 3, and which centred on the property, could not be construed as a relitigation of a matter that ex hypothesi was never before the Singapore court, hearing the matrimonial proceeding in the first place. It's important to emphasise once again the inquiry is one of substance and not form. As importantly, it is an inquiry that should not be preoccupied with fine distinctions. As we pointed out to the parties during oral submissions before us, had the appellant accepted without argument the property did not form part of the pool, she would clearly not have been precluded from initiating a claim pursuant to Part 3, simply because the property would clearly have not been the subject of the matrimonial proceedings in the Singapore court. The fact she did argue, albeit successfully, that the property ought to form part of the pool of matrimonial assets, which of course is what my client did, should not, in our view, make a difference. Indeed, to insist on drawing such a difference would be to engage in an overly technical inquiry that would produce rather arbitrary results. Such flexibility, as well as the eschewing of an overly technical approach towards the concept of relitigation, is also needful in light of the fact that by their very nature, both Part 3 and Chapter 4A of the Women's Charter would, literally speaking, often involve a consideration of the same facts that were before the court in respect of the foreign divorce proceedings. So, quite clearly, there is a parallel with here. The comity argument was considered by the Singapore court, and the Singapore Court of Appeal overturned the anti-suit injunction. And we say that is... before I hand over to Mr. Nagpal, the internal...
Mr. Howard, I'm afraid you're in some difficulties now concerning time, because you need... Court passed.
I'll send us a note or something.
Yes.
Do you want Mr. Nagpal to deal with the point in writing?
Well, perhaps Mr. Nagpal could deal with it in writing. That would be very helpful, Mr. Nagpal. Thank you very much.
Yes.
Lord Folkes has 45 minutes.
I know.
To reply.
Internal inconsistency, I'm not going to deal with any more than in our of paragraph 33. We deal with it in our case. Those are my submissions.
Thank you, Mr. Howard. Thank you very much. We're very grateful. Lord Folkes.
My Lords, my Lady, the 1984 Act was enacted to meet a particular problem identified by the Law Commission, the Ruritanian issue being the paradigm case. There were, as the working paper makes clear, a number of possible solutions to the problem which were discussed. One was to approach the matter on the basis of jurisdiction, and the law is familiar with that approach. But that wasn't the route which the Law Commission recommended. Rather, they chose the filter mechanism. During the course of questions yesterday, from the court, my learned friend said that if she had sought a divorce here, and obtained a decree, then she could have availed herself of the approach of these courts to financial relief. Now, of course, by the time she came here, the Russian courts were well and truly seized of the matter. But if, hypothetically, she had come here before the divorce and tried to obtain a divorce here, we submit she would have run into formidable and indefeasible arguments that our courts were not the convenient forum, which was clearly Russia. My learned friend blew a little hot and cold about the word lacuna. I think, in effect, he said he wasn't wedded to the word. But he did say, and I quote him, all the Part 3 cases, and he gave the court a few sparse facts in them, all the Part 3 cases were lacuna cases. I'm not sure that looking at all the cases is going to help the court very much, but we do say that in all of them there was a far greater connection with this country than there is in this case. In the final analysis, it's difficult to avoid the conclusion that when my learned friend says lacuna, he means that in all the cases there was an argument for one reason or another, that the foreign courts produced a result that did not do full justice to the applicant's case, approached on the basis of what the courts here would do. Presumably that's why the applications were made in the first place. We accept that courts in different jurisdictions may have a different approach to financial relief to one that's adopted here. For example, in the Russian proceedings, the award for child maintenance was greatly more than would have been achieved in these courts. But the fact that there is a different approach elsewhere is not the basis for improving an award made by a foreign court or topping up. And also, the family courts have their own rules and practices, as we've heard. At paragraph 48 of his judgment, and this is at EF 253, Mr. Justice Cohen said this at paragraph 48, the wording of the old FPR 8.25 had caused confusion as to whether notice should be given of an application. This was resolved by an amendment to the rules by the statutory instrument 2017, which provides as follows, and then your lordships and your lady can read what that says. The court has the power, may direct that the application be determined on notice to the respondent if the court considers that to be appropriate. And then he regrets that with the benefit of hindsight he acceded to the advocacy and concedes that there are many, perhaps most cases, are relatively straightforward. But my learned friend said, I thought it was probably a mistake on his part, but he said it twice this morning, that it was mandatory to hear this ex parte. It plainly wasn't mandatory in 2017, and it wasn't even mandatory in 2010 when one of the first of the amendments came about. It was always open to the judge to hear it inter partes. Now, I referred the court to a transcript before Mr. Justice Cohen ex parte. And my Lord Briggs pointed out, well, clearly the judge must have been aware of the new rule, and that may well be right. What we would submit is that if the husband had been represented by lawyers, I suggest it would have been made crystal clear to him that the 2017 rule post-dated Traversa and Freddie, and that he had an express power to hear the matter inter partes. And also the Court of Appeal...
Well, he clearly thought he had an express power to hear it inter partes.
He plainly did have an express power.
Well, he realised he did. He regretted that he didn't exercise it.
He realised then, but the question is the extent to which he, as it were, was directed towards the fact that Traversa and Freddie had been, to some extent, overtaken by events.
his...
Traverser and Freddie still allowed the case to be heard, the application to be heard inter partes.
Yes, although the dicta, which he refers to at length, suggested that they should be short hearings and that even...
This all comes back to the misleading point, is it? This is all the court was misled.
Indeed.
Yeah.
And that brings me to my next point. The Court of Appeal focused on the misstep taken by the judge. And I wasn't sure what Learned Friend's submissions were on whether he agreed with the Court of Appeal that Cohen J. should have heard this inter partes. All the judges in the Court of Appeal said he should have done, with the benefit of hindsight, but I think the Learned Friend's submission this morning was no, it should always have been ex parte. Well, we would say this, that the practice of the practitioners, which has been the focus of some submissions, of going ex parte on notice, which was criticised, maybe was not quite as misconceived as being suggested by Learned Friends. If this court concludes that there should have been an inter partes hearing, and there was one, then the court does not have to go into how misled the judge was, not a particularly edifying process, although we do submit the judge gave very clear reasons as to why he was misled. A Learned Friend was asked what happened when there was an ex parte on notice, and he very frankly said he did not know, and I don't claim to have the relevant experience either. But I am instructed and advised that in those circumstances, the matter, the hearing, was then listed for an inter partes hearing, very often on a day that suited the counsel, both counsel in the case. That's what happened. It seems likely that that's the case. Certainly there would then, of course, have been an opportunity for the other side to be heard.
So it would, the hearing, the ex parte on notice hearing would actually then be adjourned to a
Yes.
date for an inter partes hearing.
Precisely, the lady here. We submit, and this is at the centre of our case, that the case law on which the respondents rely makes it almost impossible to set aside an ex parte order is bad law. It is out of kilter with the law generally on ex parte applications of any other sort, and it offends natural justice. The Learned Friend says, well, all the contentious matters can be tested at a full trial and simply can't be decided without oral evidence. There was a great deal of evidence before Mr. Justice Cohen, a very lengthy witness statement, further shorter witness statements, in addition to a lengthy witness statement from the wife. There was sufficient material before the judge to conclude that the Russian courts had applied Russian law correctly. I referred at the beginning of my submissions to a chronology which is contained within the bundle, in the key documents bundle. There's a detailed chronology of all the proceedings in Russia. I don't think it would help if I took your lordships through that, but they are set out in detail. This is an agreed document as to what actually happened, and one can see that the court addressed almost all the issues which have been mentioned in passing by the Learned Friend. Of course, the approach to matrimonial property is not the same as the courts would have taken here. Ex parte, the approach taken before Mr. Justice Cohen, was because of her husband's position. In effect, the Russian courts were corrupt. The Learned Friend says, well, I didn't say that in the appropriately short ex parte hearing before Mr. Justice Cohen, but he relied on the wife's witness statement, which says in express terms that that was the case, so that what Mr. Justice Cohen was being told was an alternative argument. One, the judges were corrupt, effectively, to use shorthand, and that's a word that was used in the Court of Appeal during the course of debate. Alternatively, if they were not corrupt, then what they decided was not consistent with the way that we approach the matter in this country. We submit that on the evidence available, and without the court having to determine contentious issues, the applicant simply does not satisfy the preconditions of the Act in order to get through the leave gateway. My Lord Stevens rightly pointed out that the matters taken into account in section 16 do not preclude other matters. And perhaps I could take the court to the Act, because of course it's very important that we don't lose sight of the statute itself when we're taken along the highways and byways of various judges' comments on procedure and the like. If we go to section 16 at 2178, the heading of that section is this: duty of the court to consider whether England and Wales is appropriate venue for the application. And then before making of the order, financial order, the court shall consider whether in all the circumstances it would be appropriate for such an order to be made by a court in England and Wales, and if the court is not satisfied it appropriate, it shall dismiss the application. And then the court shall in particular have regard to the following matters. And I'll go in very briefly to the other matters. We submit that the fact that those matters are not the exclusive matters to be taken into account means the courts can take into account other matters. And this may be where the Ahmed case comes in. We submit that matters of comity and respect for foreign courts are relevant. So is the question of forum shopping and the principle that there must be an end to litigation. The desirability also of there being a clean break, something that's been reiterated many times in the context of divorce cases in this country. And the court can reasonably ask itself the question that the President, McFarlane, asked himself in the Ahmed case: would it be unconscionable? All those matters are legitimate to take into account, quite apart from the specific matters to which the court must pay particular regard. If one then looks at those matters to which the court should have particular regard,
we're not actually asked to consider the merits of this hearing, though, are we? Of the underlying
yes.
Question.
Can
I'd be
I?
interested to know how you say we should
Yes.
deal with that, because we've decided that we won't deal at this hearing with the challenge to the judge's re-exercise of his discretion.
What I submit is this, that were the court to decide, as I say it should, that the test on the set-aside is simply wrong and bad law, then what? We submit that this court is in a position, having well and truly heard both sides, to consider whether to grant the wife leave. Now, the Court of Appeal did not find it necessary to decide that point. Mr. Justice Cohen directed himself in the de novo part of his judgment in accordance with the statute, and it's difficult to imagine, we submit, an appellate court interfering with his decision if he had simply decided the case, as he should have done on the Court of Appeal's analysis, into parties. The learned friend will silently protest that that's not within the scope of the appeal. Now, if he feels wrong-footed, we would not object if he wished to put in further written submissions. But what is the alternative?
You say if you're right that the set-aside test doesn't depend on whether the court was misled during the ex parte hearing or not, it's just a revisiting. So then you would say, well, you just strike out all that first few pages of Mr. Justice Cohen's judgment after the set-aside and look at what he said when he reconsidered it. But the point Mr. Howard makes is that inevitably, perhaps, having found that he had been misled, that then coloured his approach to the Section 16 factors, so one can't just excise those and assume that everything else would have been the same.
That's his inflection point, as it were. I understand that that's his submission. And if the court thinks that it is not enough simply to say, as we invite the court to conclude, that he went through the right hoops, he came to a decision on the basis of the evidence before him, having heard both sides, then of course this court is perfectly capable, on the evidence submitted by both sides, to decide a simple factor. On the uncontroverted evidence, does the wife get through the gateway as provided by the statute? That's why we say if it would be sensible to finish this litigation here, that is our submission. And it can be done by simply, and apparently it is a simple test, to decide whether or not she satisfies the statutory criteria. And surely there is enough material advanced on both sides in this case at all stages for the court to make that decision. The reason I say we'd be perfectly happy for the learned friend to add any additional submissions is I don't want to embarrass the other side if they feel there's some crucial point which should affect, as it were, the consideration by this court of that particular the application.
He said that he was excluded from putting evidence in, and so are we going to have further evidence in the Supreme Court?
I'm not suggesting further evidence.
Well, you're not suggesting it, but he's saying that the judge excluded the possibility of further evidence being advanced by his client. And so, I mean, it would be a little bit unusual for this court to be considering evidence in first instance.
His client did put in two further statements.
I appreciate that, but the issue was, did he wish to put in further evidence, and did the judge say no?
I understand, of course I wasn't present, that there wasn't an application to put in further evidence. There was.
So there appears to be a difference.
There appears to be a dispute. I'm afraid I can't resolve that.
Well,
and if
well, appellate courts don't revisit case management decisions of that kind.
No. But I'm
His real point, I think, was that the judge made an unfair finding because there hadn't been an opportunity to respond to an allegation.
Yes.
Not that should have been allowed to put in more evidence.
But it was unfair not to.
It was unfair to make the finding he did on the state of the evidence as it was.
Yes.
And also, it's a little bit. If a respondent can in fact bring another application saying, well, I have a connection now, it's much more substantial than it was at an earlier stage, it seems a little bit odd that we can't deal with all the evidence, up-to-date evidence as to connection. And rather than having to go to the expense, further expense of compelling somebody to bring another application.
Yes, I mean, the alternatives are not attractive, which is to prolong this.
A lot of this litigation is not attractive.
No.
Yeah.
And our submission, of course, is that it should never have got beyond the application.
Well, that's your case.
Learned friend said on a number of occasions when being asked about the possibility of a further substantial hearing, whether it's 20 days or more or less or whatever, it's certainly going to be a substantial piece of litigation, that there would be more to come out. There was a slight tension, we respectfully submit in some of his submissions, between, on the one hand, the ex parte application should not be too rigorous. I think he was relying indeed on dicta, but a trial judge can only make up their mind whether the hurdle had been surmounted, provided by Parliament, only after there's been a great deal of detailed evidence. The position is effectively that a court should be able to control its own processes, which is what the judge's instinct initially was. There was a query about the analogy with judicial review. And we submit the position is this, that any defendant who wishes to take part in the permission stage of judicial review can serve an acknowledgement of service. That's CPR 5482. In the first instance, the court will generally consider the question of permission without a hearing. That's the practice direction 54A CPR para 73. An applicant can then renew the application and ask the court to reconsider a refusal of permission at an oral hearing. Para 74, practice direction 54A. And the defendant does not need to attend the oral hearing of the application, but implicitly can do so. I think that, with great respect, there's a limited amount of analogy between permission under a judicial review. This was a fairly, well, it was a completely novel piece of legislation, and the courts have worked out through various rules and dicta how it ought to be addressed. But if one looks, as is important, we submit, at the Act itself again, and even if one, as it were, accepts everything that is said on behalf of the wife, it is important to look at what the court says it should have particular regard to. The connection which the parties, and that's plural, to the marriage have with England and Wales. Absolutely none, so far as the husband is concerned. And we know the connection of his former wife. The connection which those parties have with the country in which the marriage was dissolved or annulled, in which they were legally separated. They're Russian. The connection with those parties have with any other country, the same point. Any financial benefit which the applicant or child of the family has received or is likely to receive. Well, we know there's a dispute as to whether it's 40 million or 80 million, or 80 million plus, in consequence of the divorce, annulment, or legal separation. And then the extent to which the order has been complied with, the answer is it's been complied with in full. There's no dispute about that. That's so far as the Russian proceedings are concerned. And then any right which the applicant has to apply for financial relief from any other party under the law of any country outside. So the courts are enjoined to look at what other remedies she have in her normal, her domicile. That was added to the draft bill. The availability in England and Wales of any property in respect to which an order under this part of the Act in favour of the applicant could be made. Well, there's none available in this country. The extent to which an order made on this Act is likely to be enforceable. Well, a learned friend relied on the fact that the husband had complied with every order, which is perfectly true, whether it's in Russia or costs orders in these proceedings below. But I can't give an undertaking to this court that my client will voluntarily, as it were, obey any order. Of course, he respects the rule of law, he respects this court. But that is a voluntary position. The test is whether it's enforceable. And the length of time which has elapsed since the date of the divorce, annulment, or legal separation. So we say that the court really doesn't have to resolve any difficult or contentious facts, because on the wife's case itself, this is a case which should never have been leave granted. And my friend says, well, we should have a full hearing of the matter. But if in fact the truth is that leave should never have been granted, we respectfully submit he's not entitled to that full hearing. We submit the answer is clear, there should be no full trial. So, my lords, my lady, our submission is that this litigation should end here. We invite the court to make clear that our courts do not act as the ultimate court of appeal in cases where the connection of the parties, plural, is slender in one case, and in the other there is no connection at all. That was not what the 1994 Act was dealing with. It is not what those provisions in section 16 mean, other than that this case ought to result in the case being, the order of the Court of Appeal being reversed. I should also say that there was one question about the investor visa. I understand it was £1 million then, so that was a correct observation. I think it was by my Lord Briggs. We've also sent in the directions, which I hope, Your Lordships, my lady, the directions made by Mr. Justice Francis. We agree with my learned friends that there's no rule in family courts about service out of the jurisdiction. It's something of a mystery. They do things somewhat differently in the family courts, it appears. But the family courts may do things differently, and there may be good reasons for doing them differently. But this case is about a fundamental right to be heard. And the conclusions reached in various cases about the set-aside procedure and the higher hurdle really run into the significant obstacle of unfairness. And that of itself is a reason we submit for allowing this appeal. Lord Lady, unless there's anything else I can assist you with.
Thank you, Lord Folkes. Well, Lord Folkes, Mr. Howe, we're very grateful to you both and to those sitting alongside you and behind you for the submissions that we've heard, both oral and in writing. And we're grateful for the preparation of the case. We will, of course, take time to consider our decision. Before we adjourn, there is one other matter which I should mention. Lord Folkes, I understand that this appeal is your last case before you retire from the bar. I've established that you were called to the bar as long ago as 1973, and it seems reasonable to infer, therefore, that you've decided to hang up your wig, or if I can mix the metaphors, to hang up your bat after completing a half-century. Well, it's been a very distinguished half-century, and on behalf of all of the members of the court, I extend our warmest congratulations to you and our best wishes for your retirement.